I'm Adam Wakeler, and I'm really pleased to have such an illustrious panel here today. We have Walter Dellinger, who needs no introduction in this crowd. I guess no one on this panel needs much introduction. Walter has been one of the leading Supreme Court advocates for many, many years, as well as a very well-known law professor at Duke Law School. And for our purposes, it's also worth noting that he argued the Heller case on behalf of the District of Columbia. And Rebecca Brown at the University of Southern California, one of my LA colleagues, happy to say here, one of the leading constitutional scholars in the nation, and terrific to have her as well. Jeff Stone, obviously to the ACS crowd, our board member doesn't need much introduction, but Jeff is also not only a leading law professor, especially focusing on First Amendment issues, but also the former provost of the University of Chicago and the former dean of the University of Chicago Law School. And then last but certainly never least is Sandy Levinson, who's pretty much responsible for us all being here today. Sandy at the University of Texas Law School and was one of the first progressive or liberal legal scholars to really begin to focus on the Second Amendment. And we look forward to hearing what he has to say. So the subject matter of the panel is not just the Second Amendment, so to speak, but very much in the call of the panel was about how progressives should think about the Second Amendment. This is not a debate about whether we should have a right to bear arms, but how should progressives think about the Second Amendment strategically, legally, jurisprudentially, and how should we think about resisting the Second Amendment, resisting Heller, overturning it, working within it? How might progressive ideals that we have built in other areas of the law shape and influence our understanding of the Second Amendment and the right to bear arms? And we're going to start with about 3 to 4 minutes. Each panelist will talk for 3 or 4 minutes. Then we'll have a little bit of moderated discussion, and then we'll open it up to the Q&A. I do want to ask everyone to turn off their cell phones. And when we do get to the Q&A, I want to remind you 2 things. Wait for the microphone. This is being recorded, the panel, and for later viewing on the web, and we want to have your questions as part of that, so you need to wait for the microphone. And then the second thing, of course, is that it's called Q&A, which means your whatever you say should end in a question mark, and try to keep it pretty short. And I'm hoping the question mark is not, well, this is my belief, my belief, my belief. Isn't that right? But I guess we'll take what we can get. So we're going to start. I'm going to turn it over to Walter Dellinger.
Thank you, Adam, whose book I commend to you on the Heller case. I'm not sure it's a great credential for me that I finished second in District of Columbia versus Heller, since there do not appear to be any meaningful prizes given for such a finish. Someone once said that if liberals interpreted the Second Amendment in the same way that they read the rest of the Constitution, there would be Harvard professors arguing that every American had a Second Amendment right to a government-funded gun. And so, you know, we have to answer for how we read the amendment. And I think when you ask the larger normative question that Adam posed for the panel about what our response should be, it's worth thinking about the need we have to understand why people who support a constitutionalized right to the various aspects of gun ownership and possession do so. David Cole has one of his usually trenchant pieces either out or forthcoming in the New York Review of Books on this subject. And David makes the point that we need to do 2 things as we go forward. One is we really need to understand the catastrophic level of the destruction caused by the widespread availability of guns in America and the ensuing sense that reducing gun violence is a moral imperative. But secondly, he says, we really need to recognize that there are legitimate competing interests on the other side of the ledger, interests that many Americans deeply value. 1/3 of Americans, down from a half, but 1/3 of all Americans own guns. And I think we need to understand what that means to them and what it means in the culture, and the sense that has unfortunately been created that is seen as a massive insult to people that have guns. So with that as a policy background, I have the same sense about the constitutional issues. I think if we'd had an honest constitutional debate about protections of guns, it would have started with the notion that this is not a Second Amendment issue, it's a liberty issue under the 5th and 14th Amendments. And there, I think there is certainly a claim greater than the ordinary shifting commercial arrangements, that there is an especially constitutional value in the right of self-defense. That is, if government fails to protect you and then criminalizes your ability to defend yourself, surely that raises a demand for a justification on the part of the government so deeply intrusive as to have stripped you of your ability to protect self and family. So that I think there is a legitimate constitutional notion there. And indeed, that was a libertarian background in bits and pieces before and sometimes after the adoption of the Second Amendment. That wasn't what the Second Amendment was about, in my view. And I think the overwhelming heart of the argument was about the protection of state militias from the new Constitution's radical notion that the national government could arm and therefore disarm the state militias, and that it was shoehorned in these bits and pieces. Now, why was it shoehorned into the Second Amendment? Because the reigning majority on the court refuses to recognize that judges are not just umpires, or to acknowledge that judges are not just umpires, and that where there is an especially important value, that judges have some responsibility for making constitutional value choices and explaining those value choices and defending those choices, the way John Marshall Harlan did with respect to the right of contraception, by candidly saying that here is why I believe this is a more fundamental liberty, here is why I believe, taking responsibility, moral responsibility for the decision. Instead, see Joseph Blocher on categorization and balancing in First and Second Amendment jurisprudence. Instead, the court, as it has done in other areas, hides behind some other clause, which it says gives the court no choice. There was a decision made, it's categorical. And thereby invoking a faux textualism and an ersatz originalism to hide the aspect of real choice that should be made, and to defend in terms that would require frank acknowledgement of the balancing interest on the other side. For example, the danger of handguns in crowded urban areas where they can be concealed and taken into schools and on metros, et cetera. That is my backdrop.
Great. Rebecca.
Will you say that again, just so I
I
can
will.
see? Thank you so much. I'm just going to jump right in and say that I feel that the question that we're dealing with, that the lower courts are dealing with right now, of how to apply the right recognized in Heller, the difficulty we're having even talking about it, is a direct result, or let's not say, I don't want to give a causal thing, but it illuminates one of the serious ways in which originalism itself is impoverished, and that it is a consequence of that impoverishment of the analysis. And I say that because when the court decided to recognize a right in Heller, it did not look for a constitutional principle such as the kind that Walter tried to offer to them, a principle that rises above current or past policy debates, recognize a principle, define it in our traditions and our text, and then apply it to our modern life, which is the usual practice for recognizing constitutional rights. Instead of looking for or finding a principle, the court in Heller simply looked to see, did people think they had this right then? And the analysis basically is, if we had it then, we have it now. And the court looked, how would you decide if we had it then? Well, the court looked at vignettes and stories, and you see the conflicting ones in the dissenting and majority opinions, but let's give the majority all it's due, is may say it's right as a matter of history, whatever we want to do. Still, it's stories. Like, of course we thought we had a right. Look at how people talked about it, and there are examples in the opinion as well as elsewhere. We had to go out into the wilds and face savages, and we didn't have a police force, and we didn't have a standing army, and of course we had to protect ourselves. And a lot of valid points in there that Walter alludes to. And he said, okay, we had it then, therefore we have it now. So he plucked a right that was based on context and human experience, lifted it out and dropped it into the 21st century where none of that experience and context still holds, or very little of it. Maybe there's a core there that does. And then we're expected to try to understand it. But in order to understand things, we as people look for principles. And there isn't one there, and that makes it very difficult. So the people who are trying to expand or apply the support the right to guns say, okay, well, let's make it look like the First Amendment. That's a right, and we have that. But the difference there is the First Amendment is nothing but theory. I mean, maybe it's something but theory, but it's mostly theory. There's a whole lot of theory that underlies it, and every decision is based on how the use of the expression serves the theoretical and democratic philosophy principles that the First Amendment serves. And it's a public good, the free speech, in the sense that if the government wants to restrict someone from speaking, the government doesn't only hurt the speaker. The government hurts us because we don't hear it. And so that analysis is very different. And it has to do, you have to diminish the government's interest by the fact that all of us are harmed in some way, and the democratic system itself can be harmed by the suppression of this particular person's exercise of his right. I think if we're going to look for an analog, a much more likely one is, as Walter says, what some people call substantive due process. I prefer to think of it as liberty rights, because there the model is a person wants to exercise something that's important to him or her, and the community says, no, it's dangerous to us, or it's bad for us for these reasons. That is classic ordered liberty. We've been dealing with those cases in the court for over 100 years explicitly, and before that implicitly, is what the elder Justice Harlan called the balance of ordered liberty, where we give validation to what is right, what is important in the right, based on principle, and then we look at the context in which the government seeks to suppress it and why it's seeking to do so, and the validity of its reasons. And it is a balancing, which isn't the same as the way we treat the rights under the First Amendment. So I think the ordered liberty approach is the way to look at this, and that also helps give us a little traction on what the issues are right now. So we know from Heller that the core, if you want to call it that, of what was recognized there is the right to protect oneself in one's home. Well, why would that be it? If you focus too much on the rights half of the ordered liberty balance, without the ordered part of the ordered liberty balance, you would be led, as Justice Posner just did in a recent case, to say, well, our right to defend ourselves, why would that change depending on where I am? Is my life less valuable somewhere else than it is at home? I mean, I want to protect myself at home, but why not in an airport, and why not in a school? How do you justify, in a principled way, treating those locations differently when really the right, if there is one, the interest is the same? Well, the way you get at it is what ordered liberty is all about. In the home, the government's interests are very weak. In what we read, in who we sleep with, in who we have dinner with, in what we wear, that's consistent with our constitutional principle. Government has very weak, if not zero, interests within our homes. But step outside, go to an airport, go to a school. Government has a much stronger interest in protecting the safety of people, or whatever the relevant interest is in the right. Safety happens to be the one at issue when we're talking about guns. So that makes some sense, right? But if you refuse to think about it as ordered liberty and as a balance, you can't get to that way of thinking about a legitimate basis perhaps for some kinds of rights, but also the importance of recognizing the government's interest in safety. And I would just close by saying, since 9/11, our public discourse on liberty jurisprudence has become very accustomed to talking about the liberty-security trade-off. Right? It's just common to say that, oh, you have to trade off liberty for security. We talk about it all the time. Have you heard people talk about that in connection with guns? I haven't. And it's the same idea. There may be a right there. We can challenge whether there is or not, but the court tells us there is. Okay, there is. But there is also a community interest that requires that in a principled way, we recognize that the right has to be limited in the sake of the public safety. So I would suggest that ordered liberty is the right analog. Thanks.
Great. Thank you. Jeff.
So I would ask to talk a little bit about the relationship between the Second and the First Amendments. Essentially, in Heller, Justice Scalia read out of the Second Amendment the language about the well-regulated militia. So in my view, that's the essential component of the provision, and to give meaning to it, you have to focus on the limitation to the well-regulated militia. But Justice Scalia essentially erased that and said that's just sort of background. It doesn't really have much to do with the interpretation. And so he basically rewrote the Second Amendment to say that the right of the people to keep and bear arms shall not be infringed. And then the argument is made by pro-gun advocates that the Second Amendment is like the First Amendment. Congress shall make no law abridging the freedom of speech, or the right of the people to keep and bear arms shall not be infringed. They're both absolute, straightforward provisions. And the question is, at least as a mind game, accepting hypothetically that after Heller we now have to think of the Second Amendment as if it simply erased the first clause, what would that then do to interpretation? The advocates of gun rights essentially say that means you can't regulate guns, period. And of course, part of the problem is that's not the way we've interpreted the First Amendment. Even if you play this mind game, it's not the way we've interpreted the First Amendment. On the one hand, there were those who have said, well, Congress shall make no law abridging the freedom of speech. No law means no law. End of discussion, right? But it quickly became apparent that that doesn't work. It doesn't make any sense. That what we have to know is what is the freedom of speech that cannot be abridged. And that was the point of Justice Oliver Wendell Holmes' hypothetical about the false cry of fire, right? When he offered that hypothetical, he was essentially rebutting the claim that the First Amendment means what it says. It can't mean what it says. That would mean people would have a First Amendment right to falsely yell fire in a crowded theater. That can't be true. Therefore, the First Amendment doesn't mean what it appears to mean. We have to define what the freedom of speech is. So the same thing would then be true with respect to what does it mean to say right to keep and bear arms? What is the right that may not be infringed? And you can't answer that from the text. It's not absolute any more than the First Amendment is absolute. It's easy to pose the equivalent hypothetical to the false cry of fire. That I have a right to operate my own private drones. Everybody's going to say that's crazy. That can't be what it means. So then the question is, how do you go about giving it meaning? So then the question is, I think, basically relative to the First Amendment. What have we done in the First Amendment context, right? So clearly, we have not said the First Amendment is absolute. There are all sorts of regulations of free speech that are constitutionally permissible, consistent with the text of the First Amendment. We allow the government to regulate speech that poses a clear and present danger of harm. We allow the government to regulate certain kinds of categories of speech like defamation and obscenity and commercial advertising, which we think to be less valuable, that furthers the interests of the First Amendment to a lesser degree. We allow a broad range of content-neutral restrictions of speech when they are reasonable. So the question then, the challenge then, I think, is to ask, what's the paradigm under the Second Amendment to those restrictions that we approve under the First Amendment, even assuming that the militia clause doesn't exist, which is a ludicrous assumption, but for purposes of the world we now live in, I think it's a reasonable way to think about how do you address this question. And that requires us to understand what is the core of the Second Amendment, in the same way that part of the reason we adopted the jurisprudence we have of the First Amendment is by identifying a core meaning of the First Amendment, saying what threatens that the most, what threatens it much less. That's what would have to be done as well with the Second Amendment. And whether that's a matter of personal self-protection in the home or whether it's broader than that is a question. But if we try to take the interpretive challenge that we're now faced with after Heller, I think that's a useful way to proceed, at least as a mind game.
I agree with everyone on the panel that Justice Scalia's Heller opinion is an awful opinion. I don't think, there are two ways of phrasing the question that brings together. One is how should progressive think of the Second Amendment? The other is how should progressive think about the right to bear arms? And the first one is a kind of classic law professor's question, where we talk about the text and we talk about the history and the like. The other, I mean, still a law professor's question, but as Rebecca suggests and as Walter suggests, Heller still can be an easy case if you base it on conceptions of liberty or unenumerated rights under the Ninth Amendment or privilege or immunity of U.S. citizenship. The strongest evidence, I mean, Scalia is trapped by a stupid kind of originalism that, as Reva Siegel pointed out, leads him to quote both Charles Sumner, and he doesn't have the courage to quote Justice Taney in Dred Scott. But if you put the two together, they are the strongest possible evidence for the proposition that by the 1850s there was a very widespread consensus that what it meant to be a citizen of the United States was that you had a right to bear arms. But instead he gets into these silly discussions of the Second Amendment, which, among other things, ignores the civic Republican scary aspect of the Second Amendment, that it is designed to enable a free people to rebel against an oppressive government. It has nothing to do with a liberal right of individual self-defense. That being said, what Heller stands for is a liberal right of individual self-defense, and I'm glad that Walter noted David Cole's absolutely superb article, because I think it's absolutely correct in how progressives should think. So I want to take the remainder of my couple of minutes to attack an idea being floated by a prominent Democratic senator, that is Richard Blumenthal, as to a possible amendment to the immigration bill to indicate why it indicates exactly how progressives ought not think about the right to bear arms. What David suggests is that progressives, in essence, should get over Heller, putting to one side the intricate doctrinal arguments, just as we would hope that political conservatives and our friends in the Federalist Society would get over a variety of decisions we happen to like, and talk about some of the things that Jeff has said. So Senator Blumenthal's proposal is that the immigration bill be amended to deny illegal aliens or undocumented aliens the right to bear arms. This, I think, might make some sense if the Supreme Court had rested Heller on a strong civic Republican theory of what citizens of the Republic get to do, that is, to possess a firearm in order to safeguard the values of the Republic by overthrowing a tyrannical government. That's not what Heller says. Scalia doesn't want to go there. Heller is a liberal decision about self-defense. So especially right now, where progressives ought to be pointing out that illegal aliens are human beings. Do they not bleed? Do they not have hearts? Do they not have the right to defend themselves in their home against violent attacks? The answer should be yes. That if John Roberts has that right, so should an illegal alien. So all that Senator Blumenthal is doing is feeding a terrible demonization of illegal aliens by saying they are the other. And out of a perhaps defensible desire to limit gun ownership, he wants to pick on a vulnerable group. We ought not to allow that. There was a Fifth Circuit decision that split 2-1. Unfortunately, the two said illegal aliens don't have any rights. A federal statute prohibiting an illegal alien from possessing a gun was constitutional. There was a quite interesting dissent. I think the dissent was correct. I think that's the correct progressive position if you believe in individual liberty. This also involves a former client of Walter's, and what was being discussed at the end of the extraordinarily interesting panel a few moments ago on voting rights, that is the felony exclusion from voting. Most of us in this room, I dare say, believe that felons have a right to vote. We might debate on whether Aldrich James should have a right to vote. But whether people convicted of nonviolent crimes, especially where the crimes are pure malum prohibitum and don't come close to malum and say, like Walter's former client, Martha Stewart, why, if you accept the
idea of Martha Stewart with a gun is a terrifying concept.
She's quite handy with that hot glue gun.
That if anybody in the country is entitled to defend him or herself in the privacy of one's home, then I can't for the life of me see why Martha Stewart loses that right, because she's a convicted felon. And this, I think, does dovetail with the liberal commitment, progressive commitment to restoring voting rights to convicted felons, that rightly or wrongly, the Supreme Court, and I think actually most Americans, believe that some kind of right of self-defense in one's home is a fundamental right based on liberal principles. Most of us, I would hope, would believe that some kind of right to vote is a fundamental right based on civic republican principles. But both civic republicanism and liberalism constitute our constitutional order. And it does seem to me that if we're going to argue, as we should, for treating felons better with regard to the fundamental right to vote, and nuance, not every felon, but most felons, then we ought to bite the bullet, as it were, it's a bad pun in this context, and say that there is no reason to accept the mindless exclusion of felons from the right to bear arms. And one of the many things that's awful about Scalia's opinion is that he first announces this fundamental right and then mindlessly says, but it's all right to, for all these federal statutes to limit it, without literally a sentence of explanation.
Great. Some terrific opening remarks. And what I'd like to do is, Walter, I'd like to start with you again, because one thing that I think sort of united the panel in a certain way was a discussion of the right to bear arms as a liberty interest. And I remember when I interviewed you, when I was preparing for my book, you had said to me at the time that you could have seen yourself on the opposite side of the Heller case had it not been a Second Amendment case. So can you talk a little bit more? I think that surprises, I remember it surprised me when you had first said that. Could you talk a little bit more about why that substantive due process or liberty interest, why that would protect a right to bear arms?
Well, I actually think that even the District of Columbia's handgun law would have been upheld under a substantive due process analysis, but at least it would have been a coherent and legitimate constitutional analysis, okay? I think that one of the problems we have is that the conservatives on the court, having renounced everything from Griswold forward, can't themselves admit that that's what they're doing. Look at the transcript of the argument in the Affordable Care Act case for a direct, analogy. There's all of this talk about this liberty talk. It has nothing to do with whether the Commerce Clause authorizes regulation of 1/6 of the national economy. It's really a substantive due process. The second strand that comes out in the ACA oral argument that is reflected in Heller is the notion that young and healthy are subsidizing old and weak. Well, that's a redistribution argument. That's a straight-up substantive due process redistribution argument that's going on. And yet, instead of taking honest account of that, they want to hide behind some supposed textual trick that answers the question. And what I think is the most pernicious notion in constitutional law today is the notion that that kind of faux originalism is a constraint on judicial discretion, when in fact it is exactly the opposite. It is empowering of activism because it allows you to say, I'm taking no responsibility for what I'm concluding or its consequences. If the health care goes down, if there's open season for guns, it's not me, it's not my responsibility. Whereas a more honest approach that John Marshall Harlan is reflected in his concurrence in Poe against Ullman does take responsibility, and that is a constraint on a judge, and it makes you hesitate about second guessing. So that particularly in this area, I mean, at the end of the rebuttal, on the question of whether strict scrutiny would be appropriate, assuming there was a right, unlike other rights, this is a right where, in the First Amendment area that Jeff has talked about, you are concerned constantly that there are illegitimate reasons for the regulation of speech. You're really trying to protect incumbent government. That's hardly ever true with gun regulation. The reasons are almost always legitimate. You're not looking for hidden motives. You want to protect public safety from exceedingly dangerous artifacts. And secondly, the balancing and evaluation that goes on is heavily laden with social science judgments, or judgments about how people operate in a sphere for which judges are particularly ill-suited from the cloister of their marble tower. So for all those reasons, when you engage in that kind of scrutiny, it should be with great deference and honest, what what Professor Brown says, evaluation of deference to others' assessment of the public good to be served.
Can I just follow
Yeah,
up?
yeah.
So, I mean, one interesting point that occurs to me from what Walter said is that for those who are strong advocates of gun rights, they would actually argue there is an analog to the distrust of government point, right? Because they argue that we need our guns to prevent the government from taking away our other rights. And so, whether one accepts that as a credible argument or not, it's clearly deeply embedded in their understanding, or at least their articulation of the arguments they make about the importance of guns. It's not only self-defense, it's also protection against an overbearing government, which, if they're not worried about our ability to defend ourselves, will in fact do all sorts of injustice to us. So it's interesting. In that sense, there is an argument of distrust of the government.
There was revolutionary talk in the air of the right of rebellion, but that was talk, it was the purpose of the 1787 Constitutional Convention to crush that kind of incipient egalitarianism and liberty interest. The winners of the revolution were no longer talking in revolutionary terms. That's why that even when they grudgingly agree to give the control of the militias back to the states through the Second Amendment, the emphasis is on not libertarian-sounding notions, but on well-regulated. No one ever started a libertarian principle with the phrase well-regulated.
I mean, I think with the issue of trust or mistrust, both sides, or all sides, because there are more than two, of the political spectrum are caught up in inconsistencies. That the discussion that we're having literally this week about NSA spying, the rationale for that is that there really are genuine dangers out there in the world, which certainly exist and going well beyond what we usually think of as terrorism, and that a benevolent government will protect us from these dangers by doing the kind of basically more or less unrestricted surveillance that has been revealed. Those of us, and I use us advisedly, who are a bit skeptical of an unrestrained program of surveillance, would talk about either the potential for abuse, even if we certainly trust Barack Obama, assuming he has any idea what's going on in the interstices of his bureaucracy, that he's certainly not going to turn into a tyrant. But there are other people who say, well, there are going to be other presidents who are going to come up. And so you want to have much more control over an allegedly benevolent state. And so if you do view the right to bear arms, rightly or wrongly, as being linked not only to individual self-defense in your home, but also the ultimate kind of safeguard. And if you look around the world, it's not a silly argument. A certain kind of safeguard against oppression. And you don't need nuclear weapons. Nuclear weapons are useless. Very low-level kinds of weapons can be quite useful if you're trying to mount an insurrection. And there are
drones would be helpful, though. I mean,
pardon?
Drones would be helpful.
Yes, no doubt. But these are very scary discussions to have. But as I say, I think you find them on all sides of the spectrum. It's simply that we have our issues where we focus on why we really mistrust the government, and they have their issues, and kind of it's hard for the twains to meet.
Could I make one more point about that? I mean, it's interesting because in the plenary, if some of you were there, I mean, Pam Carlin talked about the guarantee clause as a potential place for Congress to have the power to help with some of the problems we have in elections if Section 5 is struck down. But it strikes me that it's some way that's relevant to what Sandy just said. I mean, we actually do have a Constitution that anticipates dissent, anticipates overthrowing power, challenging power, changing those in power, but we have a particular way of doing it. It doesn't include guns. And Article 4 gives Congress the obligation to guarantee a Republican form of government. I don't think any of the other places in the world that are trying to overthrow their governments with guns are pretending to be carrying out a Republican form of government. And I think if you want to go that route, then you have to concede that Congress should have the power to prevent it, because it's given that obligation in Article 4.
Right.
And you know, there's an interesting issue about distrust and how that's operationalized in the courts. So one of the ways we operationalize that distrust is by having a standard of review that's very burdensome. And often, especially we think about this in some ways as a liberty right, the right to bear arms as something that's protected by the liberty components of the Constitution. Generally, progressives say that rights that are protected by those liberty components are subjected to the most exacting forms of scrutiny, scrutiny that is very distrustful, that begins with the presumption that the government is acting inappropriately there. I'm curious to get your feelings of the panel on that issue about operationalizing that mistrust, because if it is that liberty notion, and we do have a very high standard of review, it's actually going to be very difficult for a lot of gun laws to survive. Because one of the things that I found in my research is that while gun control can work, it's very difficult to come up with clear evidence of that associates particular gun control laws with the positive outcomes. Not impossible, but difficult. And I think that prosecutors and attorneys who are defending Second Amendment against Second Amendment challenges all over the country, one of their big concerns is being required to come up with good, hard evidence to show why, for instance, their assault weapons ban is constitutionally permissible. So I'm just curious, how should progressives think about that Second Amendment if we think of it as if we think of the right to bear arms maybe not as a Second Amendment issue, but as a liberty issue, where generally we want that kind of skepticism by the courts, but that might really disable gun control. Is that, how should we think about that problem? Rebecca?
Well, I think, again, what you need is a theory. And I mean, the question of why, I think the question of how heavily we scrutinize government reasons has to do with the history of, as Walter was saying, is why those liberty rights or equality rights were suppressed in the first place, and whether we tend to think that as a historical matter we would think they would be likely to be legitimate now. And it seems to me the idea that the government should have to justify restraining or justify a ban on assault weapons, it sort of begs the question of why would a person have a right to an assault weapon in the first place? Yes, we have liberties, but we also operate under the harm principle for the most part in our free society, which is that your freedom is constrained to some degree by your ability to harm others. And so I think we have to theorize what the right is about and why a particular type of weapon, maybe an assault type weapon or a bullet, armor-piercing bullets and things that the ordinary persons wouldn't be likely to need to defend their home, why those would have a heavy weight in the balance in the first place, and then we'd look at the government's right to overcome it.
Adam is correct that the courts are asking, where is the, quote, good hard evidence? But boy, that question sends me through the roof for two reasons, as asked by the courts. One is, of course, in this particular area where there has been a concerted movement to deny funding for any empirical research. Year after year, funding restrictions, no funds allocated for the Health and Human Services or for the Center for Disease Control may be expended to study aspects of, of gun violence. But that's a particular. More generally, this notion that the court is moving increasingly in the direction of treating the Congress of the United States or a state legislature or the elected representatives of a city as a kind of federal district judge or an assistant professor coming up for tenure and asking whether the empirical research meets the standards when elected officials are making judgments about the dangers of weapons, even asking questions like, where is the empirical evidence that a limit on the capacity, the bullet-carrying capacity of weapons would have any effect given the proliferation of those chambers that are already out there? Right? Well, I mean, where's the empirical evidence? Well, surely they can start to say, we want to begin, to wheedle away this notion, but it comes up again in the Voting Rights Act, where it's been well said, and this will be coming down soon at a court near you. At oral argument, the court keeps saying the question, are we persuaded that this is the best formula? Why is that the question rather than did Congress make a reasonable determination within a quite wide zone of legislative discretion to choose among the practical politics of reopening a formula or using an old formula that doesn't require reopening old ones? Are we persuaded? When did that get to be the constitutional standard? And that has been a standard that has always led the courts astray. The majority in Plessy says there's no proof that this is anything other than what the construction, the colored race chooses to put upon it. You know, where's the empirical evidence, basically? And the first Justice Harlan says in dissent, the most important words, everyone knows. That you don't need empirical evidence. Everyone knows what this is all about. So I think it's part of an increasing trend of requiring this kind of, you forgot to say may I, hoop jumping on the part of the Congress of the United States.
So, I mean, on 2 points. One is on the question of empirical data. One of the problems we have is that we have gone so long now without any meaningful gun regulation that there's, what, 300 million guns in the United States? And to begin the process of trying to regulate is going to be very difficult to have any particular regulation have a significant effect in any short-term sense. So the only way I think one can think about the empirical evidence is to compare the United States with other societies where they have had gun regulation for an extended period of time, and where it's perfectly apparent that, although there are many differences between the societies, that those that do in fact regulate guns have much lower murder rates than in the United States. And it does seem perfectly apparent that guns have a significant amount to do with that. But it's also the case that putting in place new regulations today, given the reality of the pervasiveness of guns in this society, it's not going to have dramatic immediate effects. It's going to take a very long time for any kind of regulation to really matter. On the question of deference versus scrutiny, it seems to me that, again, the First Amendment analogy turns out to be useful, is that the question is in any constitutional issue, to what extent should a court give deference, or to what extent should it be skeptical? And that's, to me, that's the central question of constitutional law. And if you take the First Amendment analogy, for instance, the court basically is skeptical in those circumstances when there is reason to believe that there's a significant risk of dysfunction in the decision-making by the government, that there are political biases and distortions that lead them to suppress certain speech and not suppress other speech because of reasons having nothing to do with the purported justifications for the laws. And so if you give deference, you're going to allow manipulation in all sorts of ways that is incompatible with the premises of the First Amendment. So the question then is that also the case with respect to guns? And as I don't remember what was Rebecca or Walter said earlier, there's no reason to believe that government is in fact manipulating gun regulation in a way that is distrustful of the purposes and values of the government. We may agree or disagree with the judgments they're making, but it's hard to see why they are problematic in the way that, say, racial discrimination is problematic or regulation of ideas is problematic. And therefore, I think from that perspective, it makes sense to give a much greater degree of deference in that context than it does in some of the others.
I think that that any of the gun control proposals that are actually on the table now are constitutional. I regard the attack on an assault weapons ban or magazine limits or background checks, that they raise serious, quote, Second Amendment, or for that matter, order liberty problems, are just frivolous. As with the reason we have a terrible medical care system in this country, it is not because of doctrine of the United States Supreme Court, it's because of the political system that we've got that makes it increasingly impossible to pass any legislation that effectively meets the challenges that face us. If there are doctrinal issues that are raised, let me return to an earlier comment, that one of them involves status discrimination against certain people who are not allowed to have a gun in their own home for purposes of self-defense, illegal aliens, and Martha Stewart. And that, I think, does raise a serious constitutional issue in a way that assault weapons does not. Secondly, I think, as Judge Posner accurately recognized, there is an interesting constitutional issue about venue. That if you do take the Supreme Court's rhetoric in Heller seriously, it is about self-defense, and it's a fair question as to whether there might not be people who would have legitimate reasons to have a gun in their mom and pop store, for example. And those, I think, we should be debating about. But I think that the debate about the nature of the weapons that can be controlled, if you adopt simply a Holmesian test of law, it's a prediction of what courts will do. In fact, even with this Supreme Court, I can't get to 5 saying, oh yes, there really is a right for everybody to have an assault weapon with an unlimited magazine and no background checks. I think that's a needlessly professorial discussion that really has almost nothing to do with the actual politics or constitutional issues that are before us right now.
The next issue I want to put on the table sort of relates to that as well. It struck me when I was listening to the oral arguments in the DOMA case and in the same-sex marriage case this year, and we saw a lot of the liberal justices on the court hesitant to rule on these issues at all, looking for procedural outs, embracing Alexander Bickle's passive virtues much more than Earl Warren's judicial activism on these issues. And it seems to me in some ways liberal jurisprudence has been transformed by a more pragmatic political sense. And I'm curious what that means or if it has any meaning for how we should think about the Heller case. Should progressives be thinking broadly about overturning Heller in the long run, or should we be thinking about working within it, maybe for reasons of political pragmatism? I'm curious, Rebecca, you have any thoughts about that?
Well, it's a hard one, I think, in a lot of ways, both mostly pragmatically, I think, more than constitutionally. I mean, for the reasons I said before, that I obviously have more elaborate defense of that position that I could do in more time, but I don't think Heller was correctly decided, which isn't to say necessarily that I disagree with Sandy when he says it could have been written with a similar outcome in a different way, possibly. I mean, I'm certainly willing to consider that, but as written, I think it was wrongly decided. But does that mean we ought to fight to overrule it? I mean, that's sort of a strategy question, and I don't really feel comfortable urging that. And I think part of it is it's very hard to overturn Supreme Court decisions, sort of generally, but also, you know, we don't want to be hypocritical. Progressives believe in rights, and I deeply believe in rights. I've devoted my career to writing about how to understand rights appropriately. And I think what's wrong with Heller, from my point of view, is that it actually does a disservice to the idea of right. The idea of announcing a fundamental right in one breath and then the next sentence saying, but of course it can be regulated. Are you kidding me? What a terrible way to dilute the precious idea of a fundamental right. So I'm hesitant to say that we should say it should be overruled, but I think the right way to cabinet for those of us who believe that it is overstated is to argue for this balanced approach where the government does have some kind of credibility, at least presumptively, that we approach it with some kind of rational basis or intermediate scrutiny kind of approach, which would give the opportunity for reasonable regulations without you know, these insuperable challenges that I was talking about.
Any of you disagree?
Well, it depends what aspect of what Rebecca was saying, because I think fundamental rights are, except I would argue for right against torture, are almost always defeasible. And the question is what the circumstances of defeasibility are, and you know, the whole tiers of scrutiny sort of stuff. But it does seem to me that, and here's why David Cole's article is so important, that politically, even if it is the case that in 2013 gun control proposals are no longer fatal to the Democratic Party coalition in a way that was the case in the 80s and 90s, where my view is that lots of working class male voters were handed over on a silver platter to the Republican Party. I'm still a bit wary of that. My view is that every one of us in this room who is delighted that Barack Obama was elected and reelected should send a case of fine wine to Antonin Scalia, whatever we think of his opinion, because I think there can be little doubt that Heller took the gun control issue off the table in the 2008 election. Can you imagine what that election would have been like if Barack Obama had been in the position either of defending a 5-4 decision, saying that the state really did have the right to take all your weapons away from you, or saying that the Supreme Court had gotten it wrong, and if he's named president, he will look for somebody who will protect one's individual right to bear arms. Scalia gave him a great gift, which incidentally, I think for political scientists in the room, is kind of useful to talk about the difference between ideological predispositions and helping your political party out predispositions. There are a number of areas in which progressive ideology trumps, or what we think of as progressive ideology trumps, over trying to keep coalitions together and winning the next election. And quite frankly, you know, I want very much to get the House of Representatives back, and I am not sure that pushing very sensible gun control measures is the way to do it, given priorities. But that's a political judgment. It's not a legal judgment.
So I think Heller was a definitively wrong decision, but at the same time, I do think that precedent is an important value and principle in our legal system, and that decisions should be overruled only in relatively extraordinary circumstances when there's clear justification, other than just that if I'd been on the court, I would have voted the other way. Not that the current majority has acted in conformity with that. They clearly have not. But in any event, I think Heller has enough ambiguity in the language that it could easily be interpreted for a very long period of time to uphold virtually any gun control law that's likely to be enacted anywhere in the United States in the foreseeable future, so that I don't think there's any need to think about overruling it in the short term. I think, you know, if we're lucky enough at some point to have 5 justices who would be willing to think about overruling it, they can accomplish an awful lot of good by simply interpreting it narrowly within the ordinary principles of constitutional interpretation without having to directly face that question.
Here's, you know, the question you raised, Adam, was about the amount of discussion in DOMA and in Perry about sort of procedural constraints on the court. And I think Heller is a good and chastening example for progressives who want to treat lightly the fundamental notion that courts have the authority to interpret the Constitution, in my view, only because they have the responsibility to resolve disputes between real litigants with a real stake in the outcome, and that they don't, you're not supposed to make up disputes. And I've been clean on this in the beginning. Always thought Flass versus Cohen was wrongly decided. And that liberals sort of cling to the notion that we don't want any standing restrictions because we want courts to decide everything, even though the courts have moved in a vastly different direction and are running off. And that's why I did a brief in the California case arguing that it was over at the district court when the California state officials failed to appeal Judge Vaughn Walker's decision. The case was over then, and there's no standing in the Court of Appeals and no standing in the Supreme Court. I actually believe in those limitations, that Marbury is about how we don't have any special authority to articulate the Constitution over other politically elected officials. We just have a job to do, and that's resolving disputes between 2 litigants applying the law of the Constitution as law. But if there's not a real dispute, we have no authority. Now, that plays out in Heller in the following way. The court was so hell-bent to decide the great Second Amendment case that they ignored the District of Columbia issue, which is this. Even assuming as I do, that the Second Amendment creates an individual right in whatever it does, even if it is protecting the ability of the state, of people to participate in the state militia. Even if one way of safeguarding the state militias is to have an individual gun ownership rights that will facilitate being able to round up a militia. Even if all that is true to protect those state militias from the overweening national government. This is regulation of a 10-square-mile area that was set aside as a security zone for the seat of the national government. The idea that Congress didn't have complete and plenary authority to regulate weapons within that 10-square-mile area, or to delegate that authority to the District of Columbia government, which also carries some of those security responsibilities for the district, it's just nuts. And yet everyone I spoke to about how much I wanted to feature the argument that for my client, the District of Columbia, that whatever you would think about a national ban applicable in Idaho and Manhattan on handguns, this is under the same, Congress's authority is under the same clause that lets it regulate Fort Bragg. It's not, and people want to say, well, does that mean that District of Columbia citizens don't have constitutional rights? They have the same rights everybody else does, but nobody has a right. They have a weapon on the base at Fort Bragg unless you're authorized by the United States Army. And I just thought it was a very powerful argument that no one at the time of the Second Amendment said, this means, of course, that in the seat of the national government, we won't have authority to regulate guns. Nobody would have thought that. This was about protecting the states, at least, and perhaps an individual right of pertinent there, too. And so it was just crazy. But everybody says, no, this is the great Second Amendment case. People have been lined up for days outside the Supreme Court with sleeping bags. So we have to ignore that and plunge ahead as if this were the great national legal issue.
I think it's a great argument.
I want to hear from you guys now in terms of what your questions are. So I'll call on you. You had your hand raised first, but let's wait till you get the microphone again so that we can have it recorded for posterity's sake.
Hi, Kristen Cabral from Virginia. My house is not that far from the NRA headquarters. Why aren't we seeing this issue through the prism that the government can regulate guns as a consumer product? So for instance, I can't bring milk to market unless it's pasteurized. I can't bring a toy to market unless it has non-chokeable parts. I can't bring a car to market unless it has seat belts. So if I'm a gun manufacturer, say, well, you could, sell shotguns on the open market to hunt squirrel or put under your bed for, protect your castle, I guess. But assault weapons, well, that's for the military or for law enforcement. They could be the consumers of those products. So, and by the way, last I checked, I had a great liberty interest once upon a time in my uterus, but the government seems to regulate that all the time, more so than guns.
Well, there are some people in the country who believe that the government should be really, really small, so small it can fit inside a woman's vagina. Any response?
Yeah, I agree with you, but I think this simply supports the argument that any legislation likely, in fact, to pass the United States Congress or a legislature, perhaps the District of Columbia City Council is the exception, I don't know, would be upheld. But it still doesn't respond to the argument that a well-manufactured handgun would be protected somewhere by, possessed by some broad range of people.
I would just say, I think that makes so much sense as a statement, right? That any dangerous product or something that could make you sick if it's not pasteurized, whatever, should be treated. But that just plays up the importance of the holding in Heller. I mean, we don't have an individual right to milk, but we have an individual right to guns for some reason, and it really moves it out of the realm of rationality, which I think most people believe gun regulations would meet that standard, of which all laws need to meet, of some basic rationality, moves it out of that standard into something that's really treated specially, and we just don't know what it is, and when people come say, well, I have a right to hunt, I mean, that's not true either. I mean, maybe people like it, but at least so far, the court doesn't, the right doesn't extend to that. I mean, I'm sure people like to race cars, but you can't do it, down I-95. So I think it just changed status, right? We have to think about it differently because the Supreme Court has put it into this place where it is different from all other consumer goods.
Yeah, put simply, the Supreme Court made guns into the analogy to books rather than the analogy to milk. That's what the court did in Heller.
It's like magazines on the newsstand and magazines at the gun store have a different role than milk at either place.
Yes, and wait for the microphone, please.
Hi, I'm Neil Siegel from Duke. This is a question about how liberals tend to talk about law and how conservatives tend to talk about law. So, Walter, there's no doubt you are right in terms of the fact of the matter in your call for honesty and transparency. If judges were umpires, then wealthy DC lawyers would not want to become them, right? There's something more that they get for being judges. Breyer called for this in Heller. Stevens tried to enact it in McDonald, and the response was Justice Scalia making fun of him and saying that his approach is incapable of restraining judicial whimsy, right? So as a matter of establishing authority, legitimacy, and as a matter of political efficacy, does it make sense for conservatives to stare people in the eye and tell them quite seriously what the Constitution means as a matter of text, history, and structure, and then for people on the left to say, well, it's hard, and this is what I feel, and here's why, and it requires judgment and balancing, and there are some important liberties at stake that I'm going to have to defend, and you may disagree, and reasonable people disagree, but nonetheless, on balance, I think we ought to protect this or not. Right? I mean, it seems to me there's a difference in the way conservatives and liberals tend to approach these things, and you can be right and lose all the time.
That's an excellent question, Neil, and I despair about it a little. I mean, I speak a lot to banquets of people who are supporting constitutional education in the schools, and I realize how hard it is against, because even that part of the public that follows public affairs closely doesn't have time to pour through 158 pages of District of Columbia versus Heller. And when there's one side that says, we're just bound by what the text says, and the other people have no mooring and no anchoring, it's very, very hard to win the debate that actually the mooring and anchoring is a green light for judges to make up their policy predispositions more than it is. I don't know how we win that. I honestly don't know how we win that debate. You're an educator, Jeff.
I mean, I actually think we can win that debate, and I think we've actually made real progress in recent years, which is not by pretending that we have black and white answers that are automatically yes or no, but by debunking the hypocrisy of the claim that we just call balls and strikes, and I think that's become, even in the public discourse now, the balls and strike business, a kind of joke. So I think we need to hammer at that. It's not that we can prove to people that we're as objectively absolutely correct as they claim they are. What we have to do is to show that what they claim is completely fraudulent and that they're doing the same thing or worse that they accuse us of doing. And the difference is it's incumbent upon us to demonstrate to people that's the case. That's the challenge. And getting there is not easy, but I actually think that society has made some progress on that. I mean, I think that the days when people thought, oh, originalism, that's neutral, that's objective, is right and wrong. I don't think people in the public generally believe that now. I haven't seen a public opinion poll on that recently, but I would guess. I think Citizens United helped us a lot on that, by the way. But I think the public are more skeptical now than they were 10 years ago about the objectivity of conservative judicial views. But we have to constantly be hammering on that.
I want to say two quick things. Walter and I think, have been agreeing probably for 40 years that it is important to have people on the Supreme Court who have a history of displaying sound judgment in important political issues, and you often display this in elected office or holding the position, say, of Attorney General or Solicitor General and the like, or being state Supreme Court. This is a stunningly inexperienced court. The only person on the U.S. Supreme Court who has held relevant federal office is Clarence Thomas, quite frankly. And nobody has ever run or been elected to office, so far as I know. For the first time in history, there's no former member of a state court. And so part of the question is, what do you really want these people, even ones we like and are glad they're on the Supreme Court rather than other people, why exactly would we want them making decisions in vast areas of the law where they really, in a certain sense, really don't know what they're talking about? Let me advert to a decision just last week, the DNA decision. Justice Kennedy's majority opinion in that case is as bad as Justice Scalia's opinion in Heller as an exercise in legal reasoning. And Justice Scalia eviscerates him in a dissent joined by Sotomayor, Kagan, and Ginsburg. But it's important to note that it's a Scalia dissent about the importance of the text of the Fourth Amendment and the importance of the warrant requirement. And it was Justice Marshall, 20, 25 years ago, who in one of the drug testing cases said, the framers made this decision for us. So it may be that these days it is more conservatives who claim that the framers made these decisions for us. But I think, frankly, it's like federalism. These are, opportunistic techniques of arguments that are available for all sides to use when convenient. But I do think, as a legal realist, I would say the most important thing at the end of the day is your belief in the sound judgment of the judge rather than their ability to show that they really deserved their summas in law school because of their cleverness in manipulating legal arguments.
Well, apropos of our subject today, the single most difficult public speaking engagement I have ever had was last September 17th when I gave the Constitution Day talk to the 3rd and 4th graders at Ross Elementary, a neighborhood public school here in the district. And I've told people that I was just exhausted trying to explain the essence of the Constitution to this group. But and you all will know the answer given the content, but said there was one and only one provision of the Constitution that excited the class. At least, let me say, half the class, the boys. And I try to get people to guess what it is. So you all would know. It was the Second Amendment, of course. So they were saying, can I take a bazooka, in the street? No, you can't. Can I bring, a smoke bomb to school? And I'd have to explain. They were really excited. I would say no. And then it was, what about, next one would be, what about a stink bomb? That was covered, I think, by the smoke bomb. The decision I did in the smoke bomb matter would govern, I'm trying to explain legal process too, but it was really hard, and they just loved the Second Amendment.
And what use is it if you can't bring a stink bomb to school, right? There's a question in the very, very back, if you can. Sorry, if you're in the very back of this area, the lights make it so I can't really see you, so you've got to send up a flare or something.
Hi, I'm Bert Moser. I'm from Texas, but I'm not armed, at least that you know of. Progressives think that the government should have the right to know every time someone if you buy a gun, but they're very reluctant to say, well, the government should know if you make a phone call. Now, is there a principal distinction between the two, and or is it that judges really do, as often charged, just make decisions not based on the Constitution, but on their politics?
Anybody want to take that on?
Yeah, I think it's a very good question. I think that the easiest distinction, and this was suggested by a question before, is that guns are inherently dangerous as objects, and that you want to make sure that people who buy even the best manufactured handgun that will be used only for proper purposes, that they meet whatever criteria you set up for being eligible to buy a gun. Whereas the argument you would make is that phone calls are not inherently dangerous. The problem with that argument is that some phone calls really are far more dangerous than guns, even assault weapons with, huge magazines. And the argument we have to wrestle with, and I'll confess, I don't know where I come out on these arguments. I think they're really, really difficult, is how much privacy we're in fact willing to waive with regard to the identification of what phone calls we make, independent of the content. It really is, whom are you calling, for how long, and what networks can this be tied to, where the argument is we're talking at the limit about existential threats to the social order, which is not the case with guns, quite frankly. But one of the things we learn to do in law school is to engage in analogies. So, it's true that what you said before, are guns more like cars or like?
Like milk or like books.
Right, right. Or my favorite one is the privileged immunities, where are elk more like oysters or something else? And you just simply have to tell students, this is what it means to think like a lawyer.
The analog to the phone call, it is an interesting question. The analog would be a law that required that every person who purchases or sells a gun has to create a record about who bought the gun and the ID on the gun, the ID number on the gun, which is put in a database which cannot be looked at unless the gun is used in a criminal offense. Mm-hmm. And that would be the analog to the phone situation. And I would think it would pose similar concerns on both sides. It would obviously be useful, no question. It would be useful. It could be abused, but I think it's a great analog. And I wonder what Second Amendment people would say to that. Would they think it's unconstitutional for the government to simply do that, where you can never look at it unless the gun is found to be used, and you want to find out who owned the gun, right? That's a good question.
Yeah, question here.
Hi, Jesse Wegman with the New York Times. I was thinking, one thing that's pretty clear when you're at places other than like an ACS convention is that for a lot of people, the issue is just extremely emotional and extremely symbolic in the way that you were saying earlier, the First Amendment is for some other slightly overlapping group of people. And what I'm wondering is whether in some way Heller is a gift in that regard. One of you, I think it was Jeff, was saying that when you look at Heller, it really doesn't limit any sort of regulation in the long run. I'm thinking in the longer term perspective on this, whether in the way that First Amendment rulings have provided something of a security blanket for people very interested in freedom of speech issues to accept that there will be regulations because the court has our back on this, whether Heller might now provide that same cover for people who care about gun rights in a very deep and emotional way to say, okay, I'll start to accept regulations because the Supreme Court has my back.
It's exactly right, I think, that Heller should effectively bring an end to the most extreme of the slippery slope arguments against any gun regulation. It is always, first if they adopt this limitation on assault weapons or magazines or the next thing you know, they'll be taking away our guns, and then you have Heller as a very strong pillar to say, no, that can't happen. The national disarmament will not happen. The Supreme Court has said it. And so I think in that way it is useful to, in the political debate over regulation.
I think it's interesting, though, when you say there's strong sentiment about the expressive value, and I think that's certainly right from what I see. And I'm not an expert on the public discourse on gun rights, but I certainly pick that up, that people care about it in that expressive way. The problem is that Heller doesn't give them that right to use a gun as a form of expression. Now, the First Amendment obviously protects expression, but usually not if it's inherently dangerous. And so I think maybe there will be First Amendment type arguments about open carry laws, maybe there have been already, Adam would know this better than I, you know, that I have a right to have it open on my hip because I want to show everyone that I believe in guns or whatever they think that represents. But I don't see that as a right that is protected by Heller. I mean, it could be expanded to reach that, but I don't see it there now. And I think we can always carry signs saying, I believe in gun rights. Maybe you could wear a plastic gun that says, I believe in gun rights. I'm not sure you could use the first, I'd be interested if my panelists agree with this, that I don't think you could use the expressive value of it as an argument beyond what Heller gives you to have a gun as an expressive.
I think David Cole's point is, if he were here, he would say, everyone in this room has enormous amounts of power. The power that comes from status, the power that comes from wealth, the power that comes from education, the power that comes from credentials. And there are a lot of Americans that feel powerless. And they live in rural areas without any of those attributes that all of us in this room have that gives us a sense of security and confidence in ourselves. And the notion that they can have and possess a gun is very important, even if they never use it, and you know, apart from hunting, and the sense in which that is very central to how people define themselves as actors in their own life story, able to assert themselves, is very, very powerful, and something I think that if you're going to have meaningful regulation, it's important to acknowledge and try to accommodate however possible.
Additional questions over here, please.
Hi, I'm Jamie Epstein from Marquette. There was some mention of post-Heller gun control legislation, but what are your thoughts on legislation like the recently enacted Kansas Second Amendment Protection Act that, one, excludes from federal regulation any personal firearm or ammunition manufactured and owned exclusively within Kansas, two, prevents any federal agent from enforcing any federal regulation or law governing any search as long as it remains within the borders of Kansas, and three, allows a county or district attorney or the Kansas Attorney General to seek injunctive relief in court to enjoin certain federal officials from enforcing federal laws regarding such a firearm.
There's a provision that says this Constitution and the laws of the United States made in pursuant thereof shall be the supreme law of the land, anything in state law to the contrary notwithstanding, and judges in every state shall be bound thereby. If you're a textualist and originalist, that answers that. I think that answers the question about that kind of legislation here and in the healthcare area as well.
Yeah, another way of putting this is that I'm much more sympathetic to the theoretical arguments for secession than I am to nullification. And this is pure nullificationism, and Walter is absolutely correct. End of story.
But these laws are becoming more popular. They're called Firearms Freedoms Act, and they are spreading in state after state. Kansas is just the latest to adopt such a law. There's been no effort to enforce them at the state level. But I think they are part of that symbolic politics that you mentioned in the earlier question about how a lot of this is not about the Second Amendment, but about the symbolic aspect of gun ownership. And these are very expressive laws, I think, for that very reason.
And there is a certain sort of analog, though I realize there are differences as well. Colorado passing a marijuana act, or other states which seemingly require for the implementation the defiance of federal law. Now, it's not pure nullification, because to my knowledge, Colorado is threatening to throw the feds into jail. But, you know, one of the issues, we're a big, diverse country, and there are lots of ways to resist what is viewed as overreaching by the national government with regard to certain important interests that some people have that other people don't, or where they're really on opposite sides.
Okay, over here. Yes, sir.
I'm Bob Weinberg from the DC Lawyers Chapter of ACS, and I'd like to ask the panel, accepting the Heller decision on the right to bear arms, whether they agree or disagree with the Supreme Court's subsequent decision that the right to bear arms was incorporated in the 14th Amendment. That seems to have, in a practical sense, a greater effect than just the Second Amendment interpretation. Well, the NRA always talked about the Second Amendment, even before Heller. Actually, what they were mainly dealing with was state laws covered by the 14th Amendment. So
I think there's a better argument for McDonald than for Heller, in my view, that the history of the 14th Amendment and the sense of a right to bear arms and locating that in the Liberty Clause of the 14th Amendment is a more plausible form of argument than, I think, the distortion. Heller, to the extent that the Second Amendment was about protecting states in the regulation of their militia from federal control, the idea that 5 people in Washington, federal officials in robes, could set aside how states might choose to regulate their militias by having all the guns, kept in as common. It's not just away from the heart of it. It's upside down. It's Washington commandeering the state regulation of guns and militia. That's why I think Heller is less defensible than McDonald. At least is in the zone of argument about whether this was a right in discourse at the time of the Civil War amendments. Sandy knows more than I do about
Well, no, I will say, and I blogged on this, the best 11-page opinion of all time was written by Jeff's colleague, Frank Easterbrook, before McDonald, in which he ridiculed the arguments for McDonald on traditional conservative grounds, the importance of federalism, the dubious status of incorporation and the like. And it is interesting, I mean, incorporation just tugs people in very, very different ideological directions.
I think that given Heller, McDonald was right. I mean, once you understand the Second Amendment the way the court did in Heller, then I don't see any really persuasive argument not to incorporate it.
It's actually an interesting little puzzle in these cases, though, which is I think that if you look at the history, there's I think a much stronger argument that the right of individuals to have a gun for self-defense was supported by the framers of the 14th Amendment, right? They had a lot of conversations about the freedmen having their right to arms confiscated by the black codes and whatnot. And so there was part of that history where you find many statements where they basically say that they believe that the Second Amendment protects an individual right to have guns for personal protection. But it's an interesting, there's better evidence for that self-defense rationale in the 14th Amendment discussion than there is in the Second Amendment discussion, where you don't see much discussion of individual self-defense against marauding Klansmen and whatnot. But it's an interesting puzzle. It's possible that McDonald could be rightly decided and Heller wrongly decided. Right? That it could be that the right understanding of the 14th Amendment was that the framers of the 14th Amendment understood the Privileges or Immunities Clause or the liberty component to protect the right of individuals to have guns for personal protection as a Second Amendment right, but they had their history wrong. And it creates a little puzzle where you could have actually had these decisions. If McDonald had come up first, it could have been decided in the way it did get decided, and maybe then Heller might have been rightly decided by a different court, apparently, maybe to go the other way. It would have, it's an interesting puzzle. I think we have time for one more question. Right there. Wait for that.
Hi, my name is Patrick Kibbe from Harvard Law School. We talked about thinking about the Second Amendment jurisprudence tied to a concept of ordered liberty. And if that were the way to think about it, it seems the next question would be how would you win the fight about what ordered liberty means in court? And that seems to be a contentious issue, given the things we've talked about today and this fight as a culture war. So what are the best progressive legal arguments for what the concept of ordered liberty means with respect to guns that could be made?
That anything passed in fact by a state legislature or Congress after they presumably held some hearings meets the prerequisites for the kind of regulation that you always get in any society, and that even if you believe in some liberty right or some Second Amendment right, this particular regulation doesn't run afoul of it. I don't think you really need to say anything more than that, frankly.
the degree of the burden would be significant. I think that's important. The degree of the burden on the right is part of that calculus. So if people say, well, we shouldn't have to be shouldn't have to license guns or whatever, or register for guns, or you'd be subject to an analysis about whether that's a reasonable burden, because we do burden rights all the time. Some of those burdens are okay, even for fundamental rights, and some are viewed as too much, right? That's a very standard construct for several constitutional rights that we view as important, even fundamental. And so one of the reasons I like this analysis, that I think that's really important, is to what degree is the burden too much, in addition to the state's interest, which is always going to be similar, I guess, or maybe it'll vary. But for example, if you really are defending your home, I mean, to what degree is it a burden not to have anything more powerful than a handgun? Maybe not so much, right? Whereas if the right is sort of just to have arms in general, then a burden that says you could only have handguns and nothing else would be viewed as more significant. So the reason I like it is I think it does focus us on how much the government is restraining the right.
If you imagine a constitution without a Second Amendment, which is the state of affairs in 98% of the nations of the world, then I think the question about regulation of guns would be no different than the question of regulation of milk or cars or anything else. And the question would simply be, is there a sufficient justification to regulate this particular product? And I would think the same very strong presumption of deference would be appropriate.
I want to take a moment to encourage students, lawyers, others who are affiliated with ACS to start thinking more about the Second Amendment and this emerging jurisprudence. It's really a developing area of law where there's a lot of work that can be done, and the work is being done mostly by people who disagree with you on these issues. This is an area that's really dominated by conservative judicial thinkers, and I want to encourage people on the liberal side of this issue to start thinking about it and start asking these questions. This is an area where it is developing. You can shape it. You can make a difference in how the courts will approach this issue. Heller is just a few years old, 5 years old. There's another 40 years of jurisprudence we probably have on this right and cases. So I encourage people to get involved. This is a great issue for progressives to help shape the law within the context of the Heller case. I want to, before I thank my terrific panelists, I do want to mention I've been asked to remind you there's a networking luncheon immediately after this panel, followed by an address by Supreme Court Justice John Paul Stevens in the presidential ballroom. And there'll be volunteers there on site to help you point your way to your table. And before we go, though, I'd like to ask you to join me in thanking my terrific panelists for a wonderful